Little Rock, you ready?
Yes, sir.
What about Fort Smith?
We're ready.
All right. Good morning, ladies and gentlemen. Today is August the 26th, 2025. It's Tuesday, and this is the Arkansas Oil and Gas Commission, a part of the Arkansas Energy and Environment, and I will turn it over to the hearing officer.
Thank you, Mr. Chairman. Good morning, commissioners. First item on the regular docket number 056-2025-08. Applicant is Flywheel Energy Production, LLC. Mr. Rankin is the attorney of record, subject of extension of temporary abandonment status. Location is Section 21, Township 10 North, Range 15 West. Counties Van Buren, Fields B43 well spacing area. Commissioners, any recusals on this matter? I don't know, for the record, there were none. Mr. Rankin, you are recognized, sir.
Thank you, Judge. Good morning, commissioners. Docket number 056, the list of pre-filed exhibits appear on page 2 of the application. They are Exhibit A, the list of parties receiving notice. Exhibit B is the fluid level test in September of 2024. Exhibit C is the proof of publication, and Exhibit D is the affidavit of notice. Originals of C and D have been provided to counsel for the commission. We've moved for the introduction of the exhibits.
Motion's granted. Those exhibits are made part of the record.
This is the application to extend the TA status for the black 10-15 1-21H well. This is the second extension for the TA status. This well requires a workover that includes lowering the tube and installing a plunger to be returned to service. The break-even price of natural gas to make the workover economic is $3.67. The applicant would, of course, comply with all commission regulations on transfer. We've moved that the extension be granted.
Thank you, Mr. Rankin. Any questions for Mr. Rankin, commissioners? Seeing none, does that conclude your presentation, Mr. Rankin? I'll call the evidentiary part of the record to a close. This matter is ready for adjudication. Is there a motion from the commission on this matter? Commissioner Lawson has moved to approve. Commissioner Weiser has seconded. All in favor, show of hands. Motion passes unanimously. Next item, docket number 057-2025-08. Applicant is Flyway Energy Production, LLC. Mr. Rankin is the attorney of record. Subject is extension of temporary abandonment status. Location is Section 22, Township 7 North, Range 16 West. County is Conway. Field is B43 well spacing area. Any recusals on this matter, commissioners? No, for the record, there were none. Mr. Rankin, you are recognized.
Thank you, Judge. The pre-filed exhibits appear on page 2 of the application. They are Exhibit A, the list of parties receiving notice. Exhibit B is the fluid level test. Exhibit C is proof of publication, and Exhibit D is the affidavit of notice. Originals of C and D have been provided to counsel for the commission. We've moved for the introduction of the exhibits.
Motion's granted. Those exhibits are part of the record.
This is an application to extend the TA status for the Charton Strassner 7-16 1-22H well. This is the first extension after receiving administrative approval. The well requires a workover that includes a stick pipe lateral cleanout and possibly a gas lift to be returned to service. The break-even price of gas to make the workover economic is $1.55. The applicant will comply with all OGC regulations. We move that the extension be granted.
Thank you, Mr. Rankin. Any questions, commissioners? Seeing there are none, does that conclude your presentation? All right, with that, I'll call the evidentiary part of the record on this docket to a close. Matters ready for adjudication. Is there a motion from the commission?
Move to approve this platform.
Chair has moved to approve. Was there a second?
Second. Jim Phillips.
Commissioner Phillips is seconded. All in favor, show of hands. Motion passes unanimously. Next item on the docket, regular docket 058-2025-08. Applicant is Flywheel Energy Production LLC. Mr. Rankin is the attorney of record. Subject is extension of temporary abandonment status. Location is section 25, township 9 north, range 8 west. County is white. Field is B43, well spacing area. Commissioners, any recusals on this matter? No, for the record, there were none. Mr. Rankin, you are recognized.
Thank you, Judge Moulton. The pre-filed exhibits appear on page 2 of the application. They are Exhibit A, the list of parties receiving notice. Exhibit B is the fluid level test. Exhibit C is proof of publication, and Exhibit D is the affidavit of notice to interested parties. Originals of C and D have been provided to counsel for the commission. We move to the introduction of the exhibits.
If that motion is granted, those exhibits are part of the record.
This is an application to extend the TA status of Cook 9-18, 14-25H36 well. This is the second extension of TA status for this well. It requires a workover that includes a full clean out and a gas install to be returned to service. The break-even price of gas to make the workover economic is $4.60. The applicant would comply with all AOGC regulations regarding TAs. We move for the extension be granted.
Thank you, Mr. Rankin. Commissioners, any questions? All right, Mr. Rankin, does that conclude your presentation?
It does.
All right, thank you. I'll call the evidentiary part of the record will close. Matter is ready for adjudication. Is there a motion from the commission? Mr. Weiser has moved to approve. Is there a second? Commissioner Lawson has seconded. All in favor, show of hands. Motion passes unanimously. Next item on the regular docket 059-2025-08. Applicant is Flywheel Energy Production LLC. Rankin is the attorney of record. Subject is extension of temporary abandonment status. Location is section 17, township 10 north, range 7 west. County is white. Field is B43, well spacing area. Any recusals on this matter? No, for the record, there were none. Mr. Rankin, you are recognized.
Judge Moulton. The pre-filed exhibits appear on page 2 of the application. They are Exhibit A, the list of parties receiving notice. Exhibit B is the fluid level test. Exhibit C is proof of publication, and Exhibit D is the affidavit of notice. Originals of C and D have been provided to counsel for the commission. We move for the introduction of the exhibits into the record.
Motion is granted. Those exhibits are part of the record.
This application to extend the TA status of the Foster 10-7 1-17H well. It's the first extension after receiving administrative approval. The well requires a workover that includes a plunger installation to the service. The break-even price of gas to make the workover economic is $2.93. The applicant would comply with all AOGC regulations for TA wells. We move that the extension be granted.
Thank you, Mr. Rankin. Commissioners, any questions? Mr. Rankin, does that conclude your presentation?
It does.
With that, I'll call the evidentiary part of the record will close. Matter is ready for adjudication. Is there a motion from the commission? Commissioner Lawson has moved to approve. Commissioner Weiser has seconded. All in favor, show of hands. Motion passes unanimously. Next item, docket number 060-2025-08. Applicant is Flywheel Energy Production LLC. Mr. Rankin is the attorney of record. Subject is extension of temporary abandonment status. Location is section 21, township 8 north, range 14 west. County is Conway. Field is B43, well spacing area. Any recusals, commissioners? No, for the record, there were none. Mr. Rankin, you are recognized.
Judge Moulton, the pre-filed exhibits appear on page 2 of the application. They are Exhibit A, the list of parties receiving notice. Exhibit D is the fluid level test. Exhibit C is the proof of publication, and Exhibit D is the affidavit of notice to interested parties. Originals of C and D have been provided to counsel for the commission. We move for the introduction of the exhibits.
Motion is granted. Those exhibits are part of the record.
This is an application for the Hill 8-14, 4-21 H28 well. This is the third extension for this well. The well requires a workover that includes reinstalling a plunger, reset a compressor, and swab and possibly tubing perforation. The continues to examine this well as a possible saltwater disposal version. The break-even price of gas to make the workover economic is $4.16. The applicant is going to comply with all OGC regulations pertaining to TA wells, and we move that the extension be granted.
Thank you, Mr. Rankin. Commissioners, any questions? Mr. Rankin, does that conclude your presentation, sir? Call the evidentiary part of the record will close. Matters ready for adjudication. Is there a motion from the commission?
Move we approve.
Commissioner Phillips has moved to approve. Is there a second?
Second.
Chair is seconded. All in favor, show of hands. Motion passes unanimously. Next item, docket number 061-2025-08. Applicant is Flyway Energy Production LLC. Mr. Rankin is the attorney of record. Subject is extension of temporary abandonment status. Location is Section 2, Township 7 North, Range 15 West. County is Conway. Field is B43 well spacing area. Commissioners, any recusals on this matter? No, for the record, there were none. Mr. Rankin, you are recognized.
Thank you, Judge Moulton. The pre-filed exhibits appear on page 2 of the application. They are Exhibit A, the list of parties receiving notice. Exhibit B is a fluid level test. Exhibit C is a proof of publication, and Exhibit D is the affidavit of notice to interested parties. Originals of C and D have been provided to counsel for the commission. We move for the introduction of the exhibits.
Motion is granted. Those exhibits are for the record.
This application is for the Mary McLaren 7-15, 2-2 H35 well. This is the second extended TA status we're seeking. The well requires a workover of installing a gas lift, the gas lift tubing installed with a packer and the valves to be, and working on the valves to be returned to service. The break-even price of gas to make this workover economic is $3.99. The applicant will comply with all OGC regulations for TA wells. We've moved that the extension be granted.
Thank you, Mr. Rankin. Any questions from the commission? Does that conclude your presentation, sir? With that, I'll call the evidentiary part of the record to a close. Matter is ready for adjudication. Is there a motion from the commission? Commissioner Bingle has moved to approve. Is there a second? Commissioner Weiser has seconded. All in favor, show of hands. Motion passes unanimously. Mr. Rankin, thank you very much. Mr. Stovall, you are up. I'm still all set. All right. Next item on the regular agenda, docket number 062-2025-08. Applicant is Flyway Energy Production LLC. Mr. Stobart is the attorney of record. Subject is extension of temporary abandonment status. Location is Section 2, Township 9 North, Range 16 West. County is Conway. Field is B43 well spacing area. Commissioners, any recusals on this matter? No, for the record, there were none. Mr. Stovall, you are recognized, sir.
Thank you, Judge. A list of pre-file exhibits appears on page 2 of the application. Those are Exhibit A, a list of parties receiving notice, B, a fluid level test, C, a proof of publication, and D, an affidavit of notice to interested parties. Originals of C and D were provided to Mr. Pilkington this morning. The applicant would move for the introduction of the exhibits.
Motion is granted. Those exhibits are made part of the record. Mr. Stovall, you're a little soft-spoken this morning. Would you be so kind as to speak up a little bit?
Happy to lean into the mic, Judge.
No problem. We've got the court reporter remote, so she probably needs to hear a little bit better. Please proceed, sir.
This is an application to extend the temporary abandonment status of the McNew 9-16 8-2H34 well. The McNew well requires a workover that would include a lateral acid treatment to be returned to service. The break-even price of the McNew well is $3.40. If the application is granted, the applicant would of course agree to all the regulations regarding TA wells, and we would move for the application to be granted.
All right, thank you, Mr. Stovall. Questions from the commission? Stovall, does that conclude your presentation, sir?
Yes, Judge.
All right, thank you. I'll call the evidentiary part of the record to a close. Matters ready for adjudication. Is there a motion from the commission?
I make a motion.
Chair has made a motion to approve. Commissioner Lawson has seconded. All in favor, show of hands. Motion passes unanimously. Next item on the regular docket 063, 2025-08. Applicant is Flyway Energy Production LLC. Mr. Stovall is the attorney of record. Subject is extension of temporary abandonment status. Section 9, location is section 19, township 9 north, range 13 west, county is Van Buren. Field is B43 well spacing area. Is there any recusals on this matter? No, for the record, there were none. Mr. Stovall, you were recognized, sir.
Thank you, Judge. A list of pre-filed exhibits appears on page 2 of the application. Those are Exhibit A, a list of parties receiving notice, Exhibit B, a fluid level test, Exhibit C, a proof of publication, and Exhibit D, an affidavit of notice to interested parties. Originals of C and D were provided to Mr. Pilkington this morning. The applicant would move for the introduction of the exhibits.
Motion is granted. Those exhibits are made part of the record.
This is an application to extend the temporary abandonment status for the Newman 9-13 2-19H18 well. The Newman well requires a workover that would include a lateral clean out to be returned to service. The estimated break-even price for the Newman well is $1.20. If the application was granted, the applicant would of course agree to the commission imposed regulations on transfer and bond.
Questions, commissioners?
Did he say the break-even price was $1.20?
Yes. Mr. Phillips.
What's the current price you're getting today?
I'm not sure I understand the question, Commissioner Phillips.
Commissioner Phillips, could you repeat the question, please?
So what is the price of gas today?
As I sit here, Commissioner, I'm unsure. I haven't checked the Henry Hub this morning.
Okay, but the $1.20, are you in reference to that's where it's economical? Is that what you said?
Yeah, yes, Commissioner Phillips.
So, okay, all right, thanks.
Same question. I think the question is, since gas prices everywhere I'm aware of is higher than $1.20, is the plan to work over and get this well back in production soon?
I do have an engineer from Flywheel here who might be better able to answer some of those questions. Or if you can step up.
All right, sir, can I swear you in, please? Do you swear or affirm the testimony you're about to give in this hearing is going to be the truth, the whole truth, and nothing but the truth?
I do.
Yeah, I was going to say, pull the microphone. You don't want to put your neck out. There you go.
There we go.
Sir, could you be so kind as to identify yourself for the record?
Yes, hi, my name is Brent Schulte.
And I'm going to turn you over to Mr. Stovall. I started doing a direct examination. My apologies.
Judge, did you swear him?
I did.
To the extent it's necessary, Mr. Schulte's credentials in petroleum engineering were first recognized in docket number 064-2022-07. That's recognized. Mr. Schulte, could you explain to the commission, your plans for the Newman well and the low break even?
Sure thing. With the low break even, so yeah, B was $1.20. So this job requires a lateral plane out. Township 9, range 13. It's a pretty deep well, just from a true vertical depth. Quite a bit of tubing out there. There's a lot of operational risk for stuck tubing, lost in hole. type risk. It's on the docket to work through, but working through our lower risk, higher priority workovers first. So that would be the reason we're not jumping on it at the $1.20 break even. Working in some operational risk into those figures.
Do you have a timeline yet?
On that particular well, I'd have to look through our inventory of work. We have one workover rig running steady throughout the play, just working through the high level candidates for restoration. I could follow up at a later date as necessary on a ETA.
All right, Commissioner Lawson, Commissioner Phillips, did you get your questions answered, gentlemen?
Yes.
Commissioner Weiser, did you have a question? You looked like you were getting ready. Okay. Thank you very much for your testimony, sir. Mr. Soba, does that conclude your presentation?
Yes, Judge.
With that, I'll call the evidentiary part of the record will close. Matter is ready for adjudication. Is there a motion from the commission?
I make a motion.
So Commissioner Lawson has already moved to approve. There's a second from the chair.
Yes.
Thank you, Mr. Chairman. All in favor, signify by show of hands. Motion passes unanimously. Next item on the regular docket number 064-2025-08. Applicant is Flyway Energy Production, LLC. Mr. Stoba is the attorney of record. Subject is extension of temporary abandonment status. Location is section 26, township 10 north, range 7 west. County is white. Field is B43 well spacing area. Any recusals on this matter, commissioners? Now, for the record, there was none. Mr. Stoba, you are recognized.
Thank you, Judge. A list of pre-filed exhibits appears on page 2 of the application. Those are Exhibit A, a list of parties receiving notice, Exhibit B, a fluid level test, Exhibit C, a proof of publication, and Exhibit D, an affidavit of notice to interested parties. Originals of C and D were provided to Mr. Pilkington this morning, and the applicant would move for the introduction of the exhibits.
Motion is granted. Those exhibits are made part of the record.
This is an application to extend the temporary abandonment status of the Smith 10-7-3-26H35 well. The Smith well requires a workover to include the installation of a plunger to be returned to service. The break-even price for that workover to be economical is $2.86. If the application is granted, the applicant will of course agree to all AOGC regulations regarding T8 wells.
Commissioners, any questions? Mr. Stoba, does that conclude your presentation?
Yes, Judge.
Thank you. With that, I'll call the evidentiary part of the record will close. Matters ready for adjudication. Is there a motion from the commission?
I make a motion.
Commissioner Weiser has moved to approve. The chair has seconded that motion. Show of hands. All right, motion passes unanimously. Next item, docket number 065-2025-08. Applicant is Flyway Energy Production, LLC. Mr. Stoba is the attorney of record. Subject is I'm sorry? Did I miss something? I'm sorry. Subject is extension of temporary abandonment status. Location is section 26, township 10 north, range 7 west. County is white. Field is B43 well spacing area. Any recusals on this matter, commissioners? No, for the record, there was none. Mr. Stoba, you are recognized.
Thank you, Judge. The list of pre-filed exhibits appears on page 2 of the application. Those are Exhibit A, a list of parties receiving notice, B, a fluid level test, C, a proof of publication, and D, an affidavit of notice to interested parties. Originals of C and D were provided to Mr. Pilkington this morning. Applicant would move for the introduction of the exhibits.
Motion is granted. Those exhibits are made part of the record.
Thank you, Judge. This is an application to extend the temporary abandonment status for the Sneed 9-12-2-4H well. The Sneed well requires a workover that would include a plunger installation to be returned to service. The break-even price for that workover to be economical is $2.86. If the application were granted, applicant would of course agree to the commission imposed restrictions on transfer and the bond requirements.
Thank you, Mr. Stovall. Commissioners, questions? Mr. Stovall, does that conclude your presentation?
Yes, Judge.
Judge Moulton?
I'm sorry?
Yeah, this is Charlie. In paragraph 1, there's a typo. The application indicates the Smith 10-7 3-26 in that first sentence.
All right, Mr. Stovall, does that need to be corrected?
Yes, Judge.
All right.
I would move to amend to make that read the Sneed well as in the rate.
That motion is granted in terms of the amendment to the application. All right, I think I closed the evidentiary part of the record down. I think we're close to adjudication, and I believe we are there at this juncture. Is there a motion from the commission with the amendment to the application? Commissioner Lawson has made a motion to approve as amended. Is there a second? Commissioner Wise has seconded. All in favor, show of hands. Motion passes unanimously. Next item, docket number 065-2025-08. Applicant is Flyway Energy Production LLC. Mr. Stovall is the attorney of record. Subject is extension of temporary abandonment status. Location is Section 4, Township 9 North, Range 12 West. Counties Van Buren. Field is B43 well spacing area. Any recusals, commissioners? No, for the record, there were none. Mr. Stovall, you are recognized.
Thank you, Judge. List of pre-filed exhibits appears on page 2 of the application. Those are Exhibit A, a list of parties receiving notice. Exhibit B, a fluid level test. Exhibit C, approval. Exhibit D, an affidavit of notice to interested parties. Originals of C and D were provided to Mr. Pilkington this morning. The applicant would move for the introduction of the exhibits.
Motion is granted. Those exhibits are part of the record.
Thank you, Judge. This is an application to extend the temporary abandonment status for the Ward Bowman 914 Austin Road E2-9 well. The Ward Bowman Austin Road well requires a workover to be returned to service. That workover would include installation of a gas lift compressor. The break-even price for the workover is $3.18. If the application is granted, applicant would of course agree to the regulations regarding TA wells.
Thank you, Mr. Stovall. Commissioners, questions? Excuse me. Does that conclude your presentation?
Yes, Judge.
All right. Call the evidentiary part of the record to close. Matters ready for adjudication. Is there a motion from the commission?
Yeah.
I state So we're confused in El Dorado.
He called 65.
He called 65 when you started. Judge.
I'm sorry, Commissioner, did I do
When
65
you
twice?
started, you recognized docket number 65.
Right. Did we skip one?
No.
Oh, we did 65 twice?
Steve,
The
the lawyer's talking about 66. What a, the well name.
Commissioner Thomas,
Let me
you're
let me
talking
read
about
let me read
66
the call.
reference with the well names.
All right, let me read the call again. We'll start it over. And my apologies. So docket number 066-2025-08. Applicant is Flyway Energy Production LLC. Mr. Stovall is the attorney of record. Subject is extension of temporary abandonment status. Location Section 9, Township 9 North, Range 14 West. Counties Conway. Field is B43 well spacing area. Mr. Stovall, you are recognized.
Thank you.
I apologize for making you do this again, but go ahead.
Well, I apologize for having to read it again to everyone. The list of pre-filed exhibits is found on page 2 of the application. Those are Exhibit A, a list of parties receiving notice. Exhibit B, a fluid level test of September 25th, 2024. Exhibit C, a proof of publication, and then Exhibit D, an affidavit of notice to interested parties. Originals of C and D were provided to Mr. Pilkington this morning. The applicant would move for the introduction of the exhibits.
All right, that motion is granted. Those exhibits are made part of the record.
Thank you, Judge. This is an application to extend the temporary abandonment status for the Ward Bowman 9-14 Austin Road E 2-9 well. The Ward Bowman Austin Road well requires a workover to be returned to service. That workover would include installation of a gas lift compressor. The break-even price for the workover is $3.15. Granted, applicant would of course agree to the AOGC restrictions on TA wells.
All right, questions, commissioners? Does that conclude your presentation, Mr. Stovall?
Yes, Judge.
Try it again. Close the evidentiary part of the record down. Matters ready for adjudication. Is there a motion from the commissioners? Commissioner Weiser has moved to approve. Is there a second? Commissioner Lawson has seconded. Show of hands. That motion passes unanimously. Thank you very much, Mr. Stovall.
Thank you, Judge.
Sometimes I've tried to compare them.
Next item on the agenda, docket number 067-2025-08. Applicant is MIS Atkins LLC. Mr. Perkins is the attorney of record. Subject is transfer of ownership. Location is section 14, township 8 north, range 19 west. County is Pope. Field is Moreland. Mr. Perkins, you are recognized, sir. Oh, wait a minute. Let me ask, any recusals on this matter, commissioners? No, for the record, there were none. Mr. Perkins, you were recognized.
Thank you, Judge. The pre-filed exhibits for this application are listed on pages 4 and 5 of the application. Those include Exhibit A, a list of parties receiving notice. B is the proof of publication. C is an affidavit of notice. D is then Director Bingle's response to a request for review dated January 3rd, 2025. E is a facility layout diagram. F is our facility photographs, a composite exhibit. G is the completed Form 1 by the applicant, and H is the completed Form 23 for both wells by the applicant. We would move for the admission of those pre-filed exhibits.
Motion is granted. Those exhibits are part of the record.
I have two witnesses with me today who need to be sworn, Mr. Steve Bills and Mr. Mike Lamb.
Gentlemen, would you be so kind as to raise your right hands? Do you swear or affirm the testimony you're about to give in this hearing is going to be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Yes.
Thank you, gentlemen. Mr. Perkins?
All right. Before we jump into the testimony, just want to give the commission some background here. These wells are currently owned by Denali Iron and Disposal. They have been inactive for more than the 1 year period, which would ordinarily trigger the requirement that they be plugged and abandoned. Denali received a notice of violation in November of 2024. There were discussions with then Director Bingle, and Director Bingle issued essentially an extension up until July 1st of 2025 for Denali was at the time anticipating a transaction with a different company. And that was the deadline to have that transaction completed and the wells to be transferred. For a number of different reasons, that transaction did not happen. The applicant here or the parent company then during that period of time began negotiating with Denali for purchase of the two disposal wells. And we are here today seeking permission to transfer those wells to MIS Atkins LLC. And then our witnesses who are here can fill you in on all the details of that. So I'd like to begin with Mr. Mike Lamb. Mike, can you just tell the commission, first of all, who you work for and what is your position there?
Hi, I'm Michael Lamb with Milestone Environmental, operating as MIS Atkins LLC here in Arkansas.
Mr. Lamb, I'm going to make a suggestion. Just pick that microphone up. Just take it out of the holder and just pass it. There you go. That way you don't have to lean over your chair. Sorry, Mr. Perkins, go ahead.
No problem. So Michael, I just want to make sure that the commissioners are clear. So the applicant here, MIS Atkins LLC, that's simply a specialty LLC that was set up by MIS Environmental to hold this particular asset when the transaction occurs. Is that accurate?
Correct.
So the parent company of MIS Atkins LLC is Milestone Industrial Solutions, is that right?
Correct.
And the parent of Milestone Industrial is Milestone Environmental Services.
Correct.
And that's who you indicated was your employer.
Yes.
So give the commission a little bit of a background on Milestone Environmental. What are their lines of business and how do they have the experience to do what we're proposing here today?
Yes, so Milestone operates 11 slurry injection facilities throughout Texas and New Mexico. In addition to that, we also operate an industrial waste processing business, and we're expanding that, and we would like to expand that into Arkansas with this project.
And has Milestone, so again, for the record, I'm just going to probably say Milestone most of the time. We're talking about the applicant, but also by implication, its parent company. So has Milestone finalized a purchase and sale agreement with Denali Industrial for the rainwater, saltwater disposal wells that we're here to talk about today?
Yes, a PSA has been executed.
Right. But the closing hasn't occurred because in order to transfer these wells, the commission has to approve that transfer. Is that your understanding?
Correct.
Right. The rainwater, saltwater disposal wells in the past have been operated as commercial saltwater disposal wells. Is that your understanding?
Yes.
But what does Milestone intend to do with these two wells? We'll call them the Rainwater 1 and the Rainwater 2 shortly.
So Milestone plans to plug the Rainwater 114 and then permit the Rainwater 214 with the ADQ as a Class 1 non-hazardous injection well.
So Milestone's intent is at least once they receive the permit from DEQ to no longer operate these as commercial saltwater disposal wells.
Correct.
Class 2 wells.
Correct.
I think then we'll pause there. If there are any questions for Mr. Lamb, and then we will ask Mr. Bills some questions.
Thank you, Mr. Perkins. Commissioners, any questions?
Yes,
Chairman?
yes. How many acres of land and do you own it?
Could you repeat the question?
How many acres of land is with your facility and do y'all own the land?
The surface facility is on 20 acres and it's a leased property.
Let me follow up on that if I may then. So this is the disposal facility is on leased property and has Denali and Milestone insured with the landowner that the lease will continue and that they have approved this new operation on the location.
Yes, Milestone and Denali have had conversations with all associated landowners to discuss the future plans and transfer of the leases.
Does that answer the question, Mr.
Will-
Chairman?
Will it only be salt water put in this SWD?
We plan to operate it as a class 1 non-hazardous industrial waste injection facility, so non-hazardous wastewater. Not necessarily salt water.
So what other type of water would be put in besides salt water?
Different wastewaters from manufacturing processes like line flushes and waters associated with like food and beverage manufacturing.
It won't be salt water. Just take it out of our jurisdiction.
So that, for the commission's benefit, Milestone is not asking this commission to approve or issue a permit or something for that type of disposal. That's a Department of Environmental Quality permit application that will occur once the transaction is completed. But in order to take over those wells and to be able to apply for that permit, they first have to allow this or ask this commission for permission to transfer the existing permits. Otherwise, under the commission's, those wells will have to be plugged and abandoned, and this transaction could no longer occur.
So there'll be the bond will be put in place before, as the transfer is done. And then if they can't get the other permit approved, and that was why we asked the questions.
Correct.
That wasn't in our sandbox.
And ask him, but I can, Mr. Lamb. So as indicated in the application, Milestone has already prearranged for, to post with the Oil and Gas Commission a $50,000 bond for each of the 2 wells, plus the $400,000 bond applicable to the surface facility. Is that correct?
Correct.
And those bonds will stay in place so long as those wells are permitted by the AOGC. Is that correct?
Correct.
If and when the Department of Environmental Quality issues its own permit, the Oil and Gas Commission permit will be terminated and the bonds will no longer be applicable. Is that your understanding?
Correct.
But the Department of Environmental Quality then will have bonding for the wells.
Still a disposal well.
So do you have plans of plugging the well before you get the other application, or what's the timeline of that?
Yes, we plan to plug the 114 prior to submitting the other application.
Is there problems with the 114 well, or you just don't need it?
For our operation, yeah, we don't need both. And then the 114 is a shallower well that doesn't meet the criteria for class 1 permitting.
Okay. Thank you.
Who will be the governing body over this injection well?
So, Chairman Langley, so long as the Oil and Gas Commission permits are still in place, the Oil and Gas Commission will be the permitting authority. At the time that the DEQ approves the transfer, the new permit, then they will no longer need the permit from the Oil and Gas Commission, and DEQ will take over responsibility for the single well that's actually going to be put into operation. By then, the rainwater number 1 will already be plugged and abandoned under Oil and Gas Commission rules.
Thank you, sir.
Any other questions from the commission? Mr. Weiser? Commissioner Bingley?
Staff looked at the list of bonds that they agreed to submit, and that each saw the criteria under B2. Staff has looked at the list of bonds that the applicant has proposed to put in place, and those 3 bonds meet all the criteria of B2.
The bonds as proposed meet the requirements.
Thank you.
under our rules.
Right, any other questions from the commission? Commissioner Bengel?
I was just gonna let you know that I will be recusing, having been the director initiating the enforcement action that this is dealing with. I think I should recuse from.
No, for the record, that Commissioner Bengel has recused from this matter. Mr. Perkins, your next witness. I'm sorry, Commissioners, any other questions? All right, Mr. Perkins, your next witness.
All right, I call Steve Bills. Steve, would you tell the commission what your position is, who you work for, and a little bit about your educational background, if you don't mind?
Sure. I'm Director of Corporate Development at Milestone Environmental Services. I've worked for Milestone 10 years. Before that with a company called R360 Environmental Solutions. Background, bachelor's degree in chemical engineering, master's degree, an MBA.
Very good. And have you dealt with disposal wells in your position with Milestone?
Correct. I helped co-author 5 patents associated with the injection of Class 2 waste in Texas and in New Mexico.
And is it correct that Milestone has done significant due diligence on these wells and determined that the number 2 well is a very much a viable candidate to be permitted as a Class 1 non-hazardous injection well?
That's correct.
As far as the rainwater number 1, explain to the commission once the application is approved, what Milestone's plans are for that well and how much time will be needed.
The rainwater 1 we plan to plug. It's advantageous for us to plug it before we apply for the Class 1 permit as an artificial penetration in our area of review. We plan to put together a plan within 60 days and for the commission's approval.
All right. So again, your plan would be to plug the number 1 well prior to formally submitting the application for the number 2 well to DEQ.
That's correct.
All right. What has Milestone, what types of testing has Milestone conducted in its due diligence on the number 2 well to determine its suitability to be a Class 1 injection well?
We've done a step rate test followed by pressure fall off test, annulus pressure test, radioactive tracer survey, and a differential temperature survey.
All right, and the results of all of those have indicated its suitability for a Class 1 injection well?
That's correct.
And have you had some preliminary discussions with Linda Hansen, the UIC coordinator at DEQ, regarding the potential viability of this well as a Class 1 injection well?
We have.
And did you receive some indication from her that it appeared, assuming that everything is as you say, that it would most likely qualify?
That's correct.
Did Milestone also contract with a third-party environmental consulting firm to conduct a phase 1 environmental site assessment of the rainwater wells in the surface facility?
That's correct.
And what were the results of that site assessment?
The results were clean. No issues or indications that there's any problems.
So in the application, Milestone has proposed some conditions that they ask the commission to include in its order, primarily a timeline. And those are listed. Those are in paragraph 16 on page 4 of the application. And those are that MIS must close the purchase of the assets within 30 days of the order effective date. Is that correct?
Yes.
B MIS must post financial assurance bonds set forth in the application, which total $500,000 within 30 days of the order effective date, but no later than 5 business days following the closing date of the purchase, whichever is sooner.
Correct.
Acceptable to Milestone.
Yes.
MIS must also submit to AOGC staff a plan for plugging and abandoning the rainwater number 1 well within 60 days of the order effective date and proceed with all diligence to plug and abandon the well upon approval. Is that correct?
Correct.
And finally, MIS must submit an application DEQ for the conversion of the rainwater number 2 well to a class 1 injection well within 90 days of the order effective date and proceed with diligence until the conversion is finally approved or denied by DEQ. In the unlikely event that conversion is finally denied by DEQ, you understand that MIS would have to return to this commission to determine the next steps.
That's correct.
Has Milestone already taken steps to prepare the application that will go into the Department of Environmental Quality to be permitted as a class 1 injection well?
Yes, we have.
I'll pass the witness, Judge.
Thank you, gentlemen. Commissioners, any questions?
Yes. Is this a sand body or limestone you're gonna be pumping this water in?
I do believe it is a sandstone.
Okay, now the $500,000 bond you're putting up, is that for? What's that $500,000 bond?
That's for the surface facility bond.
Okay, thank you, sir.
Let me make one correction there, Mr. Chairman. The $400,000 is dedicated to the surface facility, and then each of the 2 wells has a separate $50,000 bond, which is essentially a plugging and abandonment bond for each of the 2 wells. Is that right, Steve?
Yes, sir.
Thank y'all very much.
Any other questions from the commission?
I have a question. Does Milestone currently operate any similar class 1 wells in any other jurisdiction?
We do not operate any existing class 1 wells.
Anything else from the commission?
Let me follow up on that if I may.
Sure thing.
But Milestone does in its regular business deal with industrial waste in other contexts. Is that right?
That's correct.
And is Milestone in the process of also proposing conversions of some class 2 wells to class 1 in other jurisdictions?
That's correct.
And in those jurisdictions where you are looking at creating a class 1 well, have you had discussions with the communities? Are the class 1 wells considered to be beneficial to them in terms of bringing industry to those areas?
They are, yes.
Is it your understanding that there is a need for class 1 industrial waste disposal wells in general?
Yes, sir.
That's all I have.
Based on that line of questions, any follow-up questions from the commission? If not, Mr. Perkins, does that conclude your presentation?
That concludes my presentation, Judge.
Thank you, sir. With that, I'll call the evidentiary part of the record to a close. Matters ready for adjudication. Is there a motion from the commission? Commissioner Lawson has made a motion to approve. Commissioner Weiser has seconded. All in favor, show of hands. Motion passes unanimously. Ms. Perkins, thank you very much. Gentlemen, thank you. With one recusal, that's correct. We got that on the record. All right, next item on the regular, docket, docket number 068, 2025-08. Applicant is Weiser Brown Operating Company. Mr. Daly is the attorney of record. Subject is establishment of a field unit. Location is as set forth in the application. County is Ouachita. Field is East Langley Field. I know I'm going to have some recusals on this one. Commissioners, who is recusing on this matter? Commissioner
Chair.
Weiser recused, and the chair has recused.
Chair.
Any other recusals?
Thomas, I must recuse.
I'm sorry, Mr. Chairman.
Commissioner Thomas, I need to recuse also.
Thank you, Commissioner Thomas. So I have three recusals, Weiser, the chair, and Mr. Thomas. Mr. Daly, you are recognized, sir.
Thank you. The documentary evidence is tabulated on Exhibit M. I'm not sure that the remote commissioners have Exhibit M unless we can get it on the screen. So if not, I will go through it.
Mr. Daly, we're prepared to broadcast it on the.
It'll be the very last sheet in that set of exhibits.
Thank you. If you will, if you'll reference, if you have any particular exhibit that you're referring to.
There we go. All right. The applicant's documentary evidence is summarized and tabulated on its Exhibit M. It includes the request that Mr. Ken Pritchie, whose credentials were first recognized in petroleum geology in order reference number 68-85, be incorporated by reference. It also includes an affidavit by a petroleum engineer, Mr. Clifton Partridge, who sets out in Exhibit I his resume of credentials as such. Mr. Partridge, unfortunately, is on a well at the moment and was unable to travel here for the hearing. And after debating the possibility of Zoom and considering some legislation, the staff has suggested that he testify by affidavit. We move the admission of the exhibits into evidence, the incorporation by reference of Mr. Pritchie's credentials, the recognition that Mr. Partridge is an expert in petroleum engineering based upon his affidavit and resume, and request that the witnesses be sworn, or that Mr. Pritchie be sworn, actually.
Thank you, Mr. Daly. Your motion is granted. The expertise of your witnesses is recognized. We'll go ahead and swear in your witness. Sir, do you swear affirm the testimony you're about to give in this hearing is going to be the truth, the whole truth, and nothing but the truth?
State your name, please.
Ken Pritchie,
How are you employed?
consulting geologist for Weiser Brown.
You consulted with Weiser Brown as to the geologic considerations throughout the development of the East Langley Buck Range field.
Yes, sir.
From the first well to the last well.
Yes.
And also in connection with this proposed field wide unit.
Yes, I have.
Have you prepared exhibits D and E, which are the structure and isopac maps? You may want to see if we can display D and E.
Yes, I did.
Let's see if we can get them on the screen. Well, they won't be in that set. They'll be in the original.
In the original application.
Yeah.
I think they may have that already, Mr. Daly.
Yeah, I think that.
Yeah, I think they've got that.
They have those exhibits.
They do.
If you will, just go through exhibit and point out what you observe as the characteristics geologically of the proposed field.
I'm having trouble here.
This is a Buck Range Field at approximately 2,000 feet, 2,050 feet measured depth. There's there are 4 wells in the field. They're all very similar. They're on a structure with a faulted structure with a down to the south fault, north dip, and the sand. And there's an isopac map is the other exhibit showing that the Buck Range sand is approximately 10 feet gross. So all the wells are very similar in thickness and permeability. They do not vary that much from one well to the next.
Is it your interpretation that the original oil in place below these 40-acre units was approximately equal from unit to?
Yes.
And is that one of the reasons why we've proposed initial participation factors of 25% for each of the 40s?
That's correct.
Is there any fault or pinch out or other barrier which would interfere with free flow of fluids across the field?
The only is the trapping fault. No other barriers have been seen at this point.
So do you agree then that the wells are completed within a common pool?
They are, yes. My opinion, they are.
Will the ability to operate these wells in a manner of a field-wide unit as opposed to competing with one another result in a greater overall recovery of oil during primary production?
Yes, it will.
Is that because you can control the flow into each well to prevent things like coning water and things?
Yes, and plus pressure maintenance.
You also envision being able to operate the wells with one central surface facility with tanks and so forth. Will that be less costly and therefore more efficient?
Yes, that will save costs throughout the life of the well.
And also obviously reduce surface intrusion.
Yes.
Do you intend at some future point to begin secondary recovery by injecting produced salt water down dip of the oil water contact line?
Yes, that's the intent of the unitization, is to be able to inject salt water and provide pressure maintenance on this field.
Is there another field-wide unit nearby where that has been done very successfully recently?
It has. It's west and north field. It's just half a mile to 3/4 of a mile to the south of this field. Very similar in size. The Blossom and Buck Range were commingled in that field, and they had a primary recovery plus secondary recovery, and from the numbers that I gathered, the secondary recovery totaled 1.5 times the primary recovery. So it looks like a secondary recovery pressure maintenance program certainly worked in that field.
All right, let's see if we can get Mr. Partridge's exhibits now up on the screen. That's going to be A first and then L. They're in the new set of exhibits. been there. All right, there's Exhibit K. Exhibit K is a volumetric summary of the sand and fluid properties of the unit. Have you reviewed Exhibit K?
I have.
Did you provide Mr. Partridge with some of the data that he input into the model that produced it?
Yes.
Led to his conclusion?
Yes.
Do you agree with it?
I did.
All right, and likewise, Exhibit L, which is the next one, is an economic analysis where Mr. Partridge concludes that the value of additional oil to be recovered far exceeds the cost of conducting that operation. Do you agree with that?
Yes, sir.
In summary, based on your work and that of Mr. Partridge, you agree with the conclusion that the operation recover more oil and will be cost effective.
Yes, I did.
Are there questions for Mr. Pritchett?
Commissioners, any questions?
So I got one thing, no big deal, but when you were going through kind of by the operating agreement, I noticed in here on the last page of the people, I think there's some mistake on the last one where Circle L Holdings and then JC Langley underneath that, and I think it's contradicting with two different names there, a James Langley and a JC Langley. I think that
Mr. Bailey.
transparent. I showed it to a recused chairman, and he said he thought it was a mistake too.
If it was a mistake, it will be corrected.
Yeah. I'm just, it's like I say, it's no big deal. I was just bringing it to your attention.
I'll consult with my client with respect to that matter, and we will make any corrections that are appropriate.
What should it be?
It's JC Langley Oil LLC and Cindy at langley.oil.com. Instead of James Langley, it should be Cindy at langley.oil.com.
All right, we'll go ahead and make that amendment to the application. You want to make a motion for that, Mr. Daly?
So moved. Since Chairman Langley has personal knowledge, I would suggest that we should accept his testimony in that regard.
Well, since I didn't swear him in, I don't know if we can do that, Mr. Daly, but we'll take it with a grain of salt, make that amendment to the application. Your motion is granted.
He's a very truthful gentleman.
All right, any questions, commissioners? Director?
Mr. Daly, did you already turn in the original affidavit of Mr. Partridge?
I'm sorry.
The original affidavit of Mr. Partridge, the original executed affidavit. If I was going to suggest we leave the record open to receive.
I will have that probably Federal Express and get it to you. Yes.
I would just suggest we leave the record.
I'm sure it's currently in Natchez, Mississippi, but we'll.
All right, we'll go ahead and just leave the record open to provide any amendments or any additional documents that are necessary. I won't close it down, but I think we can do an adjudication regardless of that. I'm sorry. All right, Mr. Daly, anything else? Does that conclude your presentation, sir? Subject to the amendments and additions to the record, I believe this matter is ready for adjudication. Is there a motion from the commission? Commissioner Bagel has moved to approve. Is there a second?
Second.
Commissioner Lawson has seconded. All in favor, show of hands. All right. It looks like we have 6. Is that right? All right. It looks like we have 6 motions in favor of approving the application. Motion is granted. Thank you, gentlemen. Commissioners, do you need a 10-minute break before we gravitate into staff's docket? You good? Everyone good? Commissioners in the other buildings? Need a 10-minute break, 5-minute break?
I'm good.
All right, you do? We'll go ahead, go off the record. We will reconvene at 11:25.
I said I'm good. I didn't need one if you were going off the record.
Oh, I thought you said I do.
No, I said I'm good. I'm the only one here. They got to go. They recused, and I'm fine. Don't do it on my
I thought you said I do. All right. we're still on the record. Mr. Pimpleton, you give me a thumbs up when you're ready, sir. All right. First item on staff's docket, and we've got 4 of them with an overlap. Before I get into that, Mr. Pilkington, there's a couple of them that you want to dismiss, is that correct?
That's correct.
Which ones are those, sir?
Well, it's going to be docket number 54A and 55A that are after.
54A and 50. Did you say 54A and 55A?
That's correct.
56.
54A and 56A, I'm sorry.
Okay. I was going to say, now I'm really using it because I don't see a 55 at all. All right, motion to dismiss both of those matters, docket number 054A 2025-07 and 056A 2025-07 is granted, and those matters are dismissed. All right, now we have dockets 50A, 51A, 52A, 53A. And it's my understanding you want to move to consolidate those matters. Is that correct, Mr. Pimpleton?
That is correct. They're dealing with same or similar facts. There are 2 fields that are near each other, but it's the same operator, same factual situation for a well abandonment.
All right. Motion to consolidate is granted. I will go ahead and read into the record what those specific docket numbers are, as well as the operators. So they are docket number 050A 2025-07, 051A 2025-07, 052A 2025-07, 053A 2025-07. Those matters are consolidated. The operator in all 4 of those matters is RAM Energy LLC. Mr. Pilkington is the attorney of record. The subject has ordered to compel compliance. They look like they all have the same location call, section 17, township 17 south, range 27 west. And they are all the same county, Miller, as well as the same field, Falk West. Is that right?
The fields and locations are a little bit.
Section, I'm sorry, we have 1 section difference. So in 50A, we have section 17, township 17 south, range 27 west, and then 51A, 52A, 53A. It's they're all different. Okay, let me make the call better here. So 51A 2025-07 is section 35, township 16 south, range 27 west. 52A 2025-07 is section 36, township 16 south, range 27 west. And 53A is section 36, township 16 south, range 27 west. But they all are the same county, Miller, and they all are the same field, Falk.
They're either in Falk West or in Falk Field.
With that, commissioners, any recusals on these matters? Commissioner Weiser has recused. All right, Mr. Pilkington, you are recognized, sir.
Thank you, Judge Moulton. There are some pre-filed exhibits. They are the same for each of these applications. They would include Exhibit A, the Form 1, B, the affidavit of notice. Exhibit C is the copy of notice of hearing. Exhibit D is the notice of violation that was issued. And Exhibit E is the proof of public notice from the Arkansas Democrat Gazette. It's going to be that same list of exhibits for all 4 of the applications. I would move for admission of each of those exhibits into the record.
Motion is granted. Those exhibits are made part of the record.
At this time, I believe Mr. Looney may be available. I was going to take some testimony from Mr. Looney.
Mr. Looney, are you out there?
I am.
Uh-huh.
I would ask that he be.
You just see.
Yeah, you come up here.
No, he got it.
I can't quite see you, Mr. Looney, so I'm going to take it as faith that you're going to raise your right hand. Do you swear or affirm the testimony you're about to give in this hearing is going to be the truth, and the whole truth, and nothing but the truth?
I do.
Thank you, sir. Please proceed.
Thank you, Judge Moulton. Mr. Looney, you're an employee with the Oil and Gas Commission, so I'm going to ask you some questions about these applications.
I believe he's a current employee.
Hope so.
Go ahead, I'm sorry.
Mr. Looney, you're aware that we have filed an application in docket number 50A, 51A, 52A, and 53A concerning Ram Energy LLC. Is that correct?
Yes.
And the commission staff filed 4 separate applications requesting an order to compel compliance. Can you please explain to the commission why commission staff filed these applications?
Yes, sir. It had come to our attention that Ram Energy was no longer producing or basically caretaking any of these 4 wells. The date of last production ranges from approximately 2000. From 2018, I believe. I'm looking for that note. Excuse me, 2016 through 2018 is the date of last production range for these 4 wells. All 4 wells are completed in the Smackover Formation. All of them have a H2S content that is above what we would consider immediately dangerous to life and health. We have a safety concern because of that, and the fact that they're not being actively produced or looked after on a routine basis. I began my attempts with Mr. Darrell Pennington, I believe is the name, back in December of 2024. I was unable to get them to voluntarily plug or agree to any time frames for plugging these 4 wells. He had some different thoughts on them. And as you said, I ended up issuing notice of violation to try to move this along, and here we are tonight.
So at this time, is the operator in violation of what we previously called General Rule B7?
Yes, the operator has not, did not ask for a director's review at that time. He does not apply for any temporary abandonment status, and he does not plug the wells as requested.
And at this time, are you asking the commission to order the operator to plug the wells?
Yes.
And what time frame are you asking the commission to give the operators to plug these wells?
Well, given the safety concern and the fact that they've had time to begin this operation, I would ask for as minimal time as possible. The typical order says 30 days, but I understand there are 4 wells to do. So I'll have to leave that to the commission's discretion. Obviously, it's their order, their decision.
Has there been any communication with the operator in the last several months regarding these wells and plugging these wells?
There has been some off and on. They didn't have much to say to us for a period of time until the hearing app was filed, and then I believe they've actually submitted some emails to you regarding their efforts to use out-of-state entities to clear roads or do permitting or various activities.
No further questions at this time.
Thank you, sir. Commissioners, any questions for Mr. Looney?
This is Commissioner Thomas. Can you hear me? You don't have to talk loud.
Yes.
Can you hear me?
Yes, sir.
I want to ask Assistant Director Looney some questions just to have them on the record. Mr. Looney, I'm familiar with that area somewhat, and I'm concerned, as you are, about the H2S contained in those wells. But just for the record, we need to make some sort of note that the reason, in my opinion, strictly from hearsay, that the wells were closed in was because of the discontinuation of pipeline in that area. Have you heard anything about that too?
Mr. Penton informed us of that. He said that did occur, that occurred like in 2018.
It's been a long time.
And they've had 7 years to try to find another market for, if they had, it was profitable, I guess, bring in some sort of scrubber for the H2S content potentially, but.
To either one of our witnesses, have they mentioned by phone call or email whether shut-in royalties on these gas wells are being paid?
I'm not aware of that.
Okay, I didn't know that. I didn't figure we would have any way of knowing that. It's not really.
I've not received any correspondence indicating that.
All right, thank you very much. Has an inspection been done by the field staff on those locations in the last few months?
We have, it has been a few months, not terribly long, but a few months. I think, according to Mr. Pennington, they've done some further locational work with one of the wells since we were last there. There was one location that I guess a landowner had sort of blocked entry for us, finding it difficult to get access to the site. This began with a landowner complaint of one of the locations. And that location is absent of all production equipment. Everything's been removed and just the wellhead left. And they're.
Yes, thank you very much. That I'm concerned primarily with the wellheads and conditions of valving, things of that sort. It might be, we might need to put that on a priority list to keep a good eye on that. The thing that keeps going through my mind is it's been so much time, and I'm just speculating out loud. Since that pipeline is closed down, it makes me wonder whether it's ever going to be viable in the future. Also, if we'll remember, the Silverberg B2 was a re-drill that two of our former chairmen, Chad White and Ed Price, did, and that was a tremendous well. And it offers a tremendous amount of reserves still, I would suspect. So if they can't prove that there's some future for the well, I agree with the staff that they're in a precarious position. So I wish they were here today. It's the point of all this. I wish they were here to answer questions today. So that's all I've got to say. Thank you all for your presentation.
Thank you, Commissioner Thomas. Commissioner Bengel?
Once again, since I was the director under which this was enforcement was initiated, I'm going to go ahead and recuse. Eventually, things I was involved in will go away and I'll be able to.
It'll probably take a bit, Commissioner, but you'll get there eventually.
You always.
Any other Now for the record, the Commissioner Bengal has recused from
Oh,
this matter.
God, Miles reach up and can't get rid of him.
Any other questions from the commission?
This is Commissioner Wolford, is staff proposing a 30-day time period in which to plug the wells?
Yes.
Any other commissioners?
Have they given any response as to what they want to do, or they just want to leave them there, which is unacceptable? But
We received an email in the last day or two where they indicated they were going to bring in an outside the state contractor, and they were hoping to plug the wells in November, I believe. But they did not indicate that they were going to restore the wells to production. They indicated that they just needed a little bit more time to plug the wells. And our response to that is every time we try to give them a deadline, it gets extended. So we're to the point where we need to move forward with getting these plugged the best way that we know to motivate them to get it.
do they operate anything else in the state?
I'm going to defer to Gary on that. I'm not aware.
No, they do not. These are the only 4 wells that Ram Energy LLC has.
And they have any bond up for them at all? Nothing. Where they from?
I believe Tulsa.
So we got an out-of-state company with 4 wells here that we're gonna, it's got H2S and we're gonna tell them plug. I'm afraid of where that's headed.
Do they?
No, they don't have any. They don't have nothing. So we have no leverage over them as far as pulling their authority to produce or anything. So if we're gonna make them plug them, the shorter time we do it, probably is the quicker we get them back. I mean, I wouldn't give them a bunch of time if that's what we're gonna do.
Thank you, Commissioner Phillips. Any other commissioners, any questions? Director, did you have a question or a comment that you wanted to make? Okay. All right, with that, does that conclude your presentation?
Yes.
I'll go ahead and call the evidentiary part of the record to a close on this consolidated docket. Is there a motion from the commission? I'm sorry. This matter is ready for adjudication. Is there a motion from the commission?
This is Commissioner Thomas and El Dorado. I make a motion that we approve the staff's application. Now I'm gonna pick an arbitrary number, November the 15th, to have the wells plugged by November the 15th. Under the scrutiny of the El Dorado office and its staff. Thank you.
Thank you, Commissioner Thomas. Commissioner Thomas has made a motion with a slight amendment to the application staff's request. Is there a second to that motion?
Second.
Chair is seconded.
Yes, sir.
All right, all in favor, show of hands. Motion passes unanimously with Commissioner Weiser's recusal. With Commissioner Bengals as well. Correct. Thank you all very much. Next item on the docket. Is docket 069A 2025-08. Operator is operating company. The attorney of record. Subject is order to compel compliance and assessment of civil penalty. County is union. Any recusals on this matter, commissioners? All right. Commissioner Bengal has recused from this matter. Mr. Pippin, you are recognized, sir.
Thank you, Judge Moulton. There's 4 pre-filed exhibits. I would move for admission of each exhibit into the record. They would include Exhibit A, the affidavit notice. Exhibit B is the copy of notice of hearing. Exhibit C is the notice of violation issued on May 5th, 2025. Exhibit D is the proof of public notice from the Arkansas Democrat Gazette. I would move for admission of each of those exhibits.
Motion is granted. Those exhibits are part of the record.
Thank you, Judge Moulton. This is an application requesting an order to compel compliance against the operator. This one's pretty clear cut. We require an annual fee to be paid each year. We've not received payment of that fee from the operator, so we're requesting the order to be issued.
Thank you, sir. Any questions? If not, does that conclude your presentation?
It does.
All right, file the evidentiary part of the record will close. Matters ready for adjudication. Is there a motion from the commission? Commissioner Lawson has moved to approve. Second by Commissioner Weiser. All in favor, show of hands. Motion passes with the recusal of Commissioner Bengal. That concludes both the regular and the staff's docket. Moving on to open docket. The commission will now hear public comments concerning the following areas of commission jurisdiction: whether or not waste of oil and or gas is taking place or is reasonably imminent, the optimum equitable rate of production for each controlled source of supply, whether or not any rules and regulations currently in effect should be considered for revision, or if additional rules should be considered, and any other matters brought before the commission over which it has jurisdiction. Anyone present either in the room or in Zoom wish to comment on these matters? Now, for the record, there was none. And I will turn it over to Director York for his report.
Unless there's can everyone hear me okay? Unless there's some opposition, I was just gonna do the director's report from up here, because I know the microphone works well. The first item is the September 30th hearing that is scheduled for El Dorado. We have learned we're in the midst of an HVAC replacement in the El Dorado office, and we've learned that more than likely we will be without air conditioning in El Dorado for the September 30th hearing date. My proposal was to move the hearing location, but not the date, from El Dorado to North Little Rock as the most central location. That's my proposal. If there's any discussion, I'm happy to try to answer questions. Do I need a motion to reschedule a hearing?
Okay.
Thank you.
9 o'clock, 10 o'clock.
Given that we will do it in North Little Rock, we'll do it at 10 a.m. on the 30th.
And all in favor, show of hands to that motion. I don't know for the record it passed unanimously. Go ahead, Mr. Director.
Likewise, we have an issue with the October hearing. The October hearing is in conflict with as scheduled, it is in conflict with the Arkansas Lithium Innovation Summit, which is to be held here in Little Rock on the 28th and 29th of October. I have 2 suggested substitute days. The first is Tuesday, the 21st, here in North Little Rock, which would be the day preceding the APRO conference, also in Little Rock, which is scheduled for the 22nd and 23rd, or Monday, October 27th, here in North Little Rock, as the day preceding the Arkansas Lithium Innovation Summit. I'm impartial as to either of those dates.
What day of the week is the 21st on?
Tuesday.
It's on a Tuesday.
Now, I'm gonna be out of the country that prior week. So hopefully I can do whatever works.
Commissioner Lawson has a conflict on the 21st and has suggested that we adopt Monday, October 27th as the date for the October hearing here in North Little Rock, starting at 10 a.m.
I won't be here. That's fine. Y'all need Randy more than me anyway.
Commissioner, somebody needs to make a motion on the 27th or the 21st.
Later on time. Most attorneys usually prefer later in the month rather than earlier to give more time.
Later in the month has the advantage of coinciding with the notice periods, things like that. You can do it either way, but you have it earlier, you're basically sending notice while you're about to have a hearing.
Yeah. I move we approve the 27th.
Monday, the 27th, North Little Rock, 10 a.m. start time.
Second.
Show of hands. All right, the 27th and North Little Rock it is.
We need to be reminded.
And I apologize, there's several items on the director's report today. The next item is you should all have in front of you a proposed rulemaking packet. As a brief explanation, that is a copy of proposed rulemaking for the Oil and Gas Commission to assume responsibility for a certain amount of pipelines involving hazardous materials, namely CO2. What we're up against is there is a very finite window to submit our application and request to the Federal Pipeline and Hazardous Materials Safety Administration. So we're requesting that the commission vote to promulgate this rule, and if accepted by PHMSA, we move into the public comment period. We can address any of the commission's concerns regarding modification amendment at that time. So I hate to lay it on you and then ask you to vote on it in short order, but I think we have plenty of opportunity to address any concerns as it goes through the rulemaking process.
Being very familiar with the rule, I motion we adopt the rulemaking process.
So Commissioner Bingle made the motion. Is there a second? Commissioner Wiseman seconded. Show of hands, all in favor? Motion passes. Also in front of you, you should have a brief paragraph. I'm sure this has raised some curiosity. There was a statutory change in this past legislative session. Arkansas Code annotated 2519-106. In lay terms, it basically is the one for all rule. Basically, any accommodation for remote attendance of a hearing, we have to allow that for any participant, including the public. We are proposing, staff is proposing that the commission adopt the policy that is drafted in that paragraph before you, whereby the commission, when they opt to conduct hearings using any or all of our hearing locations, any participant that wants to come to El Dorado, Fort Smith, or North Little Rock
and participate in a hearing can do so. But what that prevents is individual Zoom participation, either by the public or participants. All that to say, we haven't experienced it individually with our hearings, but it's my understanding that other hearings that have conducted basically open to the public Zoom hearings for participation have turned into a pretty wild free-for-all with those doors being basically open to any and all spam, trolling, comments, chats, pictures, etc., showing as part of that administration. So our suggestion would be to be much like we're doing today, or exactly like we're doing today, is having where the commission decides to have our hearing chambers open and available for participation, that they are open and available to the commission, witnesses, any participants to any of our hearings. And that would keep us in compliance with the statutory change.
Where are commission policies? Because I don't remember us having, and if they're not in the rule, where would they be enunciated? What would be the vehicle where people would know that that is the policy?
Basically publication on the website to make them aware.
We don't want not to adopt the rule in our administrative procedures or anything.
I don't believe we'd have to adopt any rule. We can adopt it as a policy.
So, and I think you said it, I just didn't catch it. Does that go to witnesses also, or just commissioners?
Any participant would be able to come to one of our hearing chambers and participate.
So Gary can't testify from his cab, his truck with his hard hat on there.
Correct.
That's unfortunate.
Could you need a motion, Director, on that, please?
Make a motion.
Second.
Commissioner Bengal made the motion, Commissioner Lawson seconded. All in favor, show of hands. Motion passed.
And I will be very brief with my last two items. I just wanted to let the commission know that the commission ended fiscal year 2025 with healthy fund balances in both our agency trust fund as well as the well plugging trust fund. I also wanted to let the commission know that due to the change to being able to invest those funds while we're holding them, we had $718,000 in change in interest on the general trust fund, and then $376,000 in change on the well plugging trust fund that will help us any budgetary shortfall that we may have between our assessments and our expenditures. The last item, and this is a very brief update, can't recall if it was June or May, that I let the commission know about the situation with the line leak and the large tank in Norfolk. At that time, EPA had kind of told us that they didn't think that they had any jurisdiction. We've revisited the matter. Thankfully, the secretary was able to write a letter to the Region 6 administrator who asked his staff to revisit it. It's my understanding that they will be on site tomorrow looking at the tank and the lines. They still haven't made a determination, but it's nice to see our federal delegation showing up to actually lay eyes on stuff. El Dorado staff will be ready to do any tour guiding that we need to do. The last item is on the 31st of July, Flywheel graciously offered to take us out on their last of their 5 well drilling package that they had going in the Fayetteville Shale. It's first Fayetteville Shale wells that have been drilled in, I believe, about 8 years at this point. It was a neat tour, and for somebody who hasn't been on or in a rig in probably 10 to 12 years, it was pretty cool to see how much technology has advanced. There was 12, 13 staff members from North Little Rock and Fort Smith that were able to go look at that. And everybody to a person said they really appreciated and learned a lot. That's all I got for the director's report.
Alan, how's the second federal plugging funding program going? Did it get off the ground?
Well, they made an allowance regarding all the various requirements they had for endangered species and all that. I have not checked most recently, but I think we're still waiting on the notification of award and funding. So I'm sure Andrea will tell me if I'm wrong.
One question.
Yes, sir.
Did we get our funding for the second round?
We're waiting. We anticipate getting the funding for the second round. We're just waiting on the grant notification and award. But we expect to get it.
Thank you, sir.
Thank you.
We finished?
I have nothing further.
Meeting adjourned.
Thank you.
Yes, thank you. I ain't feel it all. No.